Hi everyone and welcome to today's video. In this video we will cover an evidence law / criminal law topic. The name of the case is Pooranmal versus State of Rajasthan and this is a very recent 2026 judgment. Now in this case the Supreme Court acquitted the accused who was convicted of murder because the court held that call detail records which were produced by the prosecution side they were inadmissible as they were not produced along with the mandatory section 65B certificate. Section 65B relates to Section 65B of Indian Evidence Act. Now let us delve into the case in detail. So this case arose from the 2010 murder of a woman, and the prosecution alleged that the woman's husband conspired with accused to commit the crime. Now the case against the accused rested on three pillars of circumstantial evidence. The call detail records showing frequent contact between accused and the woman's husband around the time of the offense. There was recovery of a blood-stained shirt allegedly matching the woman's blood group and recovery of 46,000 allegedly paid to him as consideration for the murder. Now, recovery of 46,000 which was alleged to be paid for the murder, the court found serious inconsistency in currency recovery because amount counted in court was only 46,145 which casted doubt on very factum of recovery. The forensic report on the shirt was also discarded for a broken change of custody and the CDRs they were found inadmissible. Now this is where evidence law becomes crucial for law students. CDRs are electronic records. Under the Indian Evidence Act 1872, electronic records when produced as secondary evidence, they must comply with Section 65B. Now Section 65B Clause 4 requires a certificate to be issued by a responsible official of the computer system who will attest that the electronic output was produced from a computer which was operating properly during the relevant period. Now the argument from the side of prosecution was that CDRs were duly proved by examining nodal officers of the telecom companies as witnesses. So state contended that non-production of 65B certificate is not fatal when records are orally proved through company employees. But the court held that Section 65B in Clause 4 clearly states that secondary evidence is admissible only if led in the manner stated and not otherwise. Thus, oral testimony of telecom officials cannot substitute the statutory certificate. Second, in the absence of Section 65B certificate, the CDRs become inadmissible in evidence, and none of the three circumstances had been proved in accordance with law. Thus, acquittal was granted and immediate release was directed of the accused.